Obviously, and I quote the federal court, as a person who has fairer rather than dark skin, which is, I was one of the people in the Eatock and Bolt case, and I think that's essentially why I can actually talk from an insider's perspective as to not just why we did certain things within the case. And I also want to acknowledge that when I speak about the case, I'm only going to speak about my personal experiences with it. There were 18 others, there were 8 other people in the case, and I do not for one moment purport to speak on their behalf, because everybody's experiences were quite dire, and that's the reason I suppose want to talk about why we did the things within the case that on the outside it looks like it was, we should have used another mechanism of which to bring Andrew Bolt to heel, but that was never its purpose. The issue was, how do non-Aboriginal people, what are the limits of the discussion about our very identity? What is the limits to that when Aboriginal peoples and communities and societies, we've already been through our own processes to talk about our inclusion or exclusion. So I want to be very clear that when I talk about my experiences with Andrew Bolt, and I have a T-shirt that reads, "I've been bolted." What was my experience of being bolted, and it means something. You probably actually want to know why we did what we did with the Andrew Bolt stuff, what's its consequence. And there is a direct link with the consequence of it to today, which is all the discussions about the repeal of 18C and 18D as an election promise, and the discussion by the newly appointed Freedom Commissioner, Tim Wilson, to the Australian Human Rights Commission, are all related to the Andrew Bolt stuff. The current discussion is it's the responsibility now, and people are blaming us for the uncertainty of one of the human rights protections, which is the RDA itself, or the Racial Discrimination Act itself, which leads me into this weird... So, wait a minute, you're saying because we used human rights protections as a means of actually protecting how we are enjoying or actually exercising our human rights, that somehow that's now become our fault that it's uncertain, because we don't want, people shouldn't use the legislation to actually protect their rights because they're political statements. And, that doesn't sit with me very well, because on the end of it, discrimination means harm, and if there is no other mechanism in law to redress harm, we've actually got to start asking ourselves some fairly serious questions about what are we as a society. And, we could always have discussions about how majority of Australians think that asylum seekers should be treated, and maybe that could be a barometer of where we're heading as a society. But, well, it is there. There is obligation. It's a tenet of our democracy that everybody can say what it is you like to say. But there's a relationship then with other rights, which is, I am not stopping you saying what it is you want to say, but there are laws that says if what you say harms somebody else, then there's a limit. That's all anti-discrimination is. It's not this, we're trumping everything else, you can't say things. It is being mindful of what you are saying, because on the other side of discrimination, as I've suggested, is harm. You don't actually mount a anti-discrimination matter before a court or a tribunal suggesting, what they said was really beneficial. You've actually got to show that there was harm, and it is on you to show that there is harm done to you. And, I have no problem as a lawyer. I think that's fine. And as a citizen, I think that's fine. You've got to be able to express how it hurts you or how it harms you. Some of it will be patently obviously. There's obviously physical and emotional costs to harm. Not so much reputational costs, and I'll come back to that because that was the direction that people wanted us to take with Andrew Bolt. Why didn't you just sue him for defamation? Well, he didn't defame us. Aboriginality is not a reputation worth protecting. It's not a reputation. It is who you are. It is part of you. And on the basis of understanding that, the law has said in Australia and internationally, what we don't do is then use that attribute that is not, again, not a reputation, to actually say things that are going to harm you on the basis of that attribute. So, back to it's not a reputation. So what is Aboriginality? And I think that's really important for here. And why is the Racial Discrimination Act the most important protection that we all have? I mean, it's not fanciful to say that whiteness could also be caught in anti-discrimination law. If a group of blackfellas are going after you just because you're white, and on the basis of that, all of that sort of stuff, it's not impossible to imagine where that could take. So this notion from non-Indigenous people, non-white people, because I think the public discussions and certainly the public support for the non-amendment to the Racial Discrimination Act is coming from religious quarters. It's also coming from there's a whole raft of otherness that is saying, please don't tinker with the Race Discrimination Act, because it's not just about race, it's about colour, national or ethnic origin or religion is caught in race, or the Racial Discrimination Act. So the attributes of indigeneity that is worth protecting is exactly the reason we did not go after Andrew Bolt through defamation laws. And also, one of the defences in defamation and under the RDA is public interest. And one of those issues that was raised was just because there's issues about Aboriginality in the public arena does not make it of itself public interest. So, Andrew Bolt. Right. 18C of the Racial Discrimination Act said it is unlawful for anybody to offend, insult, humiliate or intimidate. Offend and insult seems to be what gets people upset right now. The case, and that's the bar is set too low. It is not just a matter of being merely offended. Andrew Bolt wrote scurrilous, inaccurate, demeaning and damaging stuff about us in the press. By his own admission, he is read or syndicated to 4 to 5 million Australians every day. That's a lot of influence, of which his suggestion was, and I quote, he referred to me as a gay white man masquerading as a black woman. No, a gay white man with a law degree masquerading as a black woman with my snout in the trough. So, where? What the hell? And the issue with that isn't so much that I was offended. What's the effect of that kind of rhetoric on people's willingness, ability, and especially vulnerable people, vulnerable Aboriginal people who are, and the court got to there, about how you even identify. If that's what's going to be levelled at you, would you actually go down that path? So, and what he said about the others is just as scurrilous and just as inaccurate. We all know that we would have won defamation. Those of us in the group that were lawyers were positive, but that wasn't the issue of why the Racial Discrimination Act was the appropriate mechanism, because he went after Aboriginal people, not us as individuals. We were the litmus test of his. He could not identify his Aboriginality in us, and therefore he attacked Aboriginality as being, you cannot be successful, whatever that's meant to be. Because look at who he went after. I mean, it wasn't just... And without investigating any of our personal histories, where we've come from, his marker of success was, as soon as you get a certain level, then you are impacting other people's neediness and you are not Aboriginal. That's essentially what the argument was put forward. His team ran the argument that political communication and public interest, just because Aboriginality is also not a political status. we're people. That other people think it's okay to talk about in the abstract, as men do about women, as straight people talk about gay people and lesbians and bi and transgendered and intersex. It's not an abstraction. We are people, and this is the mechanism of which we are protecting our right to live with dignity and equality. So what Bolt was saying was he couldn't recognise anything of the way he sees Aboriginality in this group, that were fairer rather than darker, and this is what Andrew, the judge, was on. So we didn't go defamation. We went because this was protecting Aboriginal and Torres Strait Islander people from incursions into our very essence. Because there is effects when people, not just us that were harmed, there are effects on allowing that level of revolting speech to influence others to share that view. And therefore, others start to impede our ability to live with equality and dignity. So the effects of it, but more so the biggest issue was the future. We didn't do it. We're all fairly strong people. Do you think we don't look the way that we do and thinking... And we all existed very publicly, so we kind of knew who we were. You think that would have been ground level, be certain of who you are before you go public, existing as an Aboriginal person, looking not a stereotype. But it was the future generations. I have a son who is as fair as me, but he is also as Aboriginal as me. And I know a lot of his friends are in the same situation. Andrew Bolt was found to intimidate people out of mere identity of itself. That is why we went after him, and that is why the court said this was actually dangerous. And there is a defence, public interest. He didn't even get near it because it's not in the public interest the way he went about his so-called journalism. Anyway, I'm out of time, but that's where we're at. Thank you.